In conclusion, on behalf of the Law Society of Kenya, I am currently before your brother Honorable Gideon Kiagi Kahawa Law Courts virtually to proceed on our colleagues' behalf on the plea taking of Mr. Chacha Mwita today in the morning. I am laying a foundation that there is a trend, Your Honor, on justice actors, both from the bar and from the bench, on weaponized attempts to criminalize the functions and services that are offered by advocates. If we proceed this way, and I believe that our colleagues from the DPP also agree with us, that the manner in which the subjects before you were arrested and presented to the DCI was improper. That is number one. Number two, on behalf of Gaylene Makena, she was denied, together with the other subjects before court, the singular issue of bail. It is a constitutional issue. And while at it, for 3 long days, being a lactating mother, she did not see her baby, and no health intervention was provided for her. On the part of Mr. Daniel Mongi Kamau, he was at the wrong place at the right time. The DPP himself confirms that he himself and his property, being the motor vehicle in question, was not subject of the inventory that the DCI had provided. When the DCI went to the residences of the subjects before you, and especially with a key focus on the officer of this court, there were children in their houses, and they carried away tools of trade, being laptops, being mobile phones, and to add injury upon, to add insult to an injury, they carried files, client files that have no nexus relationship to this present investigations. The Law Society owner will be writing to the Director of Public Prosecutions, principally not only to complain, but to request the Office of the Director of Public Prosecution to intervene in this abuse, not only of power, but of process. We are living in an interesting time, Your Honor. If they can come for innocent citizens like Daniel, and they can also come for innocent practitioners of law, such as Ms. Makena, Your Honor, it is not lost that they can also come for anyone in this room, and particularly yourself, Your Honor.
They came for me, you defended.
When they came for Mr. Danson Omari, and he is a very good teacher of law from the Catholic University of Eastern Africa, we put up a serious case.
Yes.
And that matter was settled in the High Court. Your Honor, client-advocate privilege is the sacrosanct mortar that binds our practice of law. Without it, we have no business calling ourselves legal service providers. So I am appealing to my colleague from the DPP, and I thank him, in fact, for his candor and industry in his admission that we can collapse one application after the other, but also to look at the possibility that since we have started from a point of contention in terms of the processes that were begun by the DCI, there may be a possibility that this matter may not take off. So I am saying that as we collapse probably the third application by Mr. Daniel with consent, let us look at the possibility that this matter may not take off in its very nature. And finally, Your Honor, as I conclude, because I do not want to take the court's time, there are persons that are listed as respondents in that particular application by the DCI who have since not been arrested, nor, and their whereabouts are known. Their whereabouts are known. What we are trying to say is that there are specific parties that are being targeted unfairly. Your Honor, an officer of the court such as Ms. Makena should serve as a final precedent on the weaponization against members who provide professional services and specifically members who provide legal services. I submit, Your Honor, and as I sit down, I want also to thank you because I have appeared before you severally and I know that you are of good heart and that you have had us. I thank you, Your Honor.
Your Honor, the President fighting for the seat has brought a personal issue I didn't want to disclose to this court. But now that he has been brought, let me disclose it, that at one time, when the DCI came for Dr. Fred Matiang'i, we defended him. The next person who was summoned was me. And the file went to the DPP then, and the DPP declined to charge. So I have had a history how the DCI can push hard against advocates. That is a personal experience I've encountered. The two Law Society of branches fought so hard, otherwise I could be now in committee prison for defending one of my clients. Let it go on record that the DCI must be tamed or else they have the capacity to be wrong.
To bring on record the chairperson of the Nairobi branch to also come on record.
Your Honor, my name is Eric Kivuva. I serve as the chair of the LSK Nairobi branch. When this matter was brought to my attention, it was very concerning because we are in charge of practice and welfare of advocates. I thought I would come to court today just to dissuade the court from taking this journey to nowhere that is being instigated by the prosecution. And the manner in which our member, an advocate of the High Court, was handled is totally unacceptable. Especially because all this was done before the order was issued. And we say that there is no legality that can arise from an illegality. In fact, I would invite this court to have everything collapse on that basis alone. The prosecution should withdraw everything against the counsel and start afresh. Do things the right manner. Because an illegal process cannot give birth to a legal process. It is dead on arrival. The seizure of an advocate's tools of trade, including files for children's matters, is unacceptable. The seizure of our mobile phones and laptops and what have you is a breach of advocate-client confidentiality. And from where we sit, Your Honor, we will not take it lying down. and we invite this court to do the right thing, correct the injustice that has been occasioned by the conduct of the prosecution and the police, and send a warning that these kind of applications will not be misused to detain people illegally. The last time we had detained or illegal detentions was during the KANU regime. And the state cannot be aided by court to have such things occur. Counsel was detained for 3 days. I don't know whether it had been brought to the attention of the court, but counsel is a lactating mother. For 3 days, she was not accorded bail, a constitutional guarantee, a constitutional right. That in itself reeks of malice and maybe an agenda that maybe the prosecution needs to bring to the attention of the court, because it may seem that whatever it is not aimed at justice. Thank you all.